Number 59, Nitkewicz versus Lincoln Life and Annuity Company. Counsel.
Good afternoon, Your Honors. Seth Ard, Sussman Godfrey, on behalf of plaintiff. I'd like to reserve 3 minutes for rebuttal, please.
You may.
An annual premium is paid for a year. That simple point resolves this appeal. The statute requires Lincoln to refund any premium paid for any period beyond the death of
But the money's paid, was it paid simply for the coverage, or did it do with the value of the account?
Thank you, Your Honor. And that's, I think, a key point on this appeal. The statute does not say any period of coverage, and I think that's dispositive of really the central argument that Lincoln's making in this case. The statute says that a refund is owed for any premium paid for any period. It does not say any premium paid for any period of coverage. It does not say it's restricted to any premium for coverage. It says any premium, and that's any premium.
What's the appropriate definition of premium? What is a premium?
A premium is money that's paid to an insurance company.
For any purpose whatsoever?
Well, I believe so, and this policy itself defines the thing that's being paid, the planned annual premium. Sorry, it doesn't define it, but it calls it a premium. It's the exact same word is used in the statute and the policy.
Do you think a planned premium is the same thing as a premium?
A planned premium is a type of premium, Your Honor. Going back to the original question,
how do we know
I'm sorry.
How do we know what a period is? How are you explaining what a period is?
A period is time period.
Well, so it can be, but is it, let's take this contract example.
Sure.
What is the time period for this contract?
Well, a planned premium is a planned annual premium. It says annual in capital letters. What any premium for any period means under the statute for any period means is a premium that is connected to a time period in the policy. So you have a planned annual premium, and it's paid, that premium is paid for a year. That's the definition of annual.
Is it of any
Isn't
moment?
that about the frequency as opposed to the period?
Yes, it is the frequency, but there is no distinction between a premium that's payable once every year and a premium that is paid for a time period. What the statute, what for any period means in the statute is you look at whether the premium is tied to a time period in the policy.
But it does seem to be a different kind of policy, right? This universal policy has particular investment advantages. I mean, it seems to me to be very much an investment tool. It's a complex financial instrument in that way. Doesn't that take it out of the coverage of the statute?
No, Your Honor, it fits within the plain language of the statute. I think I'd like to go back to that first question because I think it's the key question on this appeal, whether of coverage should be read into the statute. The word is not there. Of coverage is not in the statute. It says any premium paid for any period. The legislature knew how to say of coverage if it wanted to. If you look at A1, which is the interlocking statute, A1 talks about a premium that is sufficient to keep the policy in force for 3 months. If in A2, they wanted to restrict the premiums that were being talked about to only premiums for coverage.
If the value of the policy, if there's money in excess, the premiums can be paid from that.
That's true, Your Honor, but again, the statute doesn't talk about what the purpose of the premium is. It refunds any premium paid for any period.
So universal life is the same as the traditional life insurance policies that existed, and so they should be under the same rules. Is that what you're saying? There's no difference in any of the types of policies.
Oh, there's lots of differences. There are thousands of different kinds of policies that are out there.
Correct.
This statute applies to all of them on its face.
So suppose the policy here didn't have the planned premium language, so that you could pay in any time you wanted and there was no planned premium. What would the result be then?
Well, Your Honor, that would be a very different case. It's not the question
that's what I'm
I understand. That's not the question that's asked by the Second Circuit, of course. They're asking for whether a planned premium is covered by the statute. If it was not tied to any specific time period, the premium payment?
That is, if the contract did not have the planned premium language. We stripped that out. Now we have the same contract, except that's missing. What's the result?
Well, again, not this case, but a court could easily say that since the policy does not tie the payment of the premium to any time period, it is not covered by the statute.
And so when you say tie the payment to a period, you're not saying it must be required, but simply allowed or described?
Correct. The statute does not say any mandatory premiums. It does not say any premiums paid for coverage. It says any premiums. So it doesn't matter what's mandatory or not.
How would you read the statute applied to a traditional whole life policy?
In the same way. I think this is actually a good way to think about this. Think about a term policy. Everybody agrees that an annual term premium is refundable. Now let's imagine you have a term policy that has a $1,000 annual premium, okay? And let's say the policy breaks it down.
Well, the term is easy. I'm trying to ask about.
Well, I think that this hopefully will illustrate my point.
Right.
Let's say the term premium says $800 of that $1,000 annual premium is for cost of insurance. $150 is for the annual administration fee, and $50 is for annual access to an expedited help desk. Okay? Under the statute, the entire $1,000 premium is refundable. It does not matter whether the premium is paid for coverage, whether the annual premium is paid for administration fee, or whether the annual premium is paid for expedited access or for access to an expedited help desk. All that matters under the terms of the statute is that the premium is paid for any period.
But
And
that's
an
what
annual
I-
premium by definition
But
is paid for.
that was my question before. The money is used here in the universal life policy. If I'm understanding this policy structure, you can correct me if I'm wrong.
Yes, Your Honor.
Is being used for particular types of investments. It's also available to the insured for loans. So it's not like the charges that you just described, that money. I think of it as the money's in the basket. You throw money in the basket, you're hoping to get more money coming from this, and on occasion, you take money out to pay for that insurance coverage. Am I misunderstanding the way the structure works? It may sound very simplistic, so bear with me, but that seems to me to be the way this policy functions.
Well,
And both sides are getting all these advantages from that money being in the basket.
Sure, Your Honor. I think a few points. First, the subjective intent of the insured doesn't matter. A lot of Lincoln's brief suggests you have to figure out whether the premium is paid for coverage or for investment purposes or something else. The statute doesn't suggest anything like that. It would make no sense to interpret a statute that requires an insurance company to pay a refund to turn on what the subjective intent of the policyholder is. That's point one. Point two, they
Well, I
didn't...
didn't mean it as subjective intent, I meant it as the structure of
Right.
the policy.
Well, yes, it is true that under the policy, you can take out policy loans, for example. It's also true under some term loans, or term policies. That has not, the statute doesn't say anything about...
Counsel, what's the relationship between the monthly deductions and the policy value? Are the monthly deductions the same all the time, or if there is more in the policy value, are they less? I'm trying to understand what value the insured derives from the policy account. Well, let me start with the first question. Are the monthly deductions constant from month to month?
They are not constant.
And
no.
what are they a function of if they are not
Cost of
constant?
insurance rate and what's called the net amount at risk, which is sort of if you look at the total account value and you look out at the death, it's the death benefit minus the account value.
And so
which
it
can
bears
vary.
no relationship to how much is in the policy account, but is only a function of when you estimate someone might die and the cost of insurance, which I assume is relatively static.
Sorry, it does relate to what's in the policy account.
So how
the
does it
charge does.
relate to that?
The net amount at risk is defined as the death benefit minus what's in the policy account.
So if the policy account exceeds the death benefit, the monthly deduction could theoretically be minimal.
Well, under IRS regulations, that's actually not supposed to happen.
But it could actually be lower, couldn't it? It couldn't even have to cover the costs. A planned premium,
That's correct.
one might not even cover the costs. So then how would that work in your pro rata?
Well, again, and that's why I think the essential point in this appeal, is that there is no of coverage written in the statute. It says any premium for any period. Lincoln reads that to mean any period of coverage. But in my example with a term premium, you can have part of your premium pay for an annual administration fee. It's not for coverage. You can have your part of your annual premium pay for access to an expedited help desk. That's not for coverage.
Counsel, if you go back to the statute, and I think the trouble I have a bit is applying this statute to a very different kind of animal here than term life.
Sure.
But the statute's aimed at, look, the insured dies, the insured has paid for a risk coverage that now isn't going to happen. So the insurance company has essentially collected money to insure for a risk that can no longer happen. So 3 months of premiums you've paid, the insured dies, you know, the first month, there's 2 months where, what are they insuring anymore, right? So you should get that back. Here, that's not what's happening, right? So you've paid, let's say, $50,000 into this account. They take out whatever. Really, all this is a function of is whether you choose one option to get what's in the account plus 1.5 million, or to get 1.5 million. The client here chose to get 1.5 million. So to the older question, the question before, you're kind of self-insuring in a way up to a certain point each month because your premium's going down and you're getting that benefit based on what you have in the account. If you've chosen option 1, you get 1.5 million if there's an event. If you've chosen option 2, you get 1.5 million plus whatever in the account. And it seems like we're trying to jam a statute that does something very differently onto this situation to cover something it was never intended to cover.
Well, 3 points, Your Honor. One thing the statute covers is a situation where you pay for coverage beyond the period of the death of the insured. But the
That was
statute
the
isn't
purpose
limited
of
to
that
that.
statute.
The statute isn't limited to that. It
But
doesn't.
you're reading it not to be limited to that. But what would be the purpose of not limiting
Oh,
it to that?
well, the purpose is what the statute itself says. The purpose is to prevent life insurance companies from keeping premiums that were paid for a period beyond the death.
And you're defining that premium to include something that, again, I'm having trouble fitting into the purpose of that statute, because they haven't taken this money out of the account. It's in the account, 50,000, whatever, however much is left after the load fee. And your client, the insured's estate would get that if you chose one option, but they chose a different option. So
But-
they're not getting that, they're getting 1.5 million, and that's the bargain they made.
Right. So that argument is about whether we're really trying to get the death benefit option B is what it's called, what you're referring to. And the answer is absolutely not,
But
because
what are you trying to get that the insurance company shouldn't be collecting, which is, to me, what the purpose of this statute
payment,
is?
sorry, Your Honor.
No.
Payment for a period beyond when the contract terminated. It's as simple as that.
I guess to
Again, go back to I'm sorry.
I was going to get to Judge Garcia's question a little bit differently. In the statute, there is a provision that says that you don't get the money back if there's a policy provision for waiver of premium benefit. Can we read option 1 as essentially that waiver?
No, waiver of premium benefit refers to a situation, this is in the statute too, refers to a situation where you have a premium that you'd otherwise have to pay, but you're too old or you're sick and so you don't pay it.
That's a
And so that-
specialized meaning.
Well, that's what it means in the statute, what it means in this policy. And that's why it's so clear that what actually paid means is when you actually pay a premium. You know, Lincoln, their interpretation of the statute makes no sense. What Lincoln is saying is that actually paid in the statute refers to when the monthly deduction is taken out. But the statute says premiums that are actually paid. Policyholders pay the premiums. Insurance companies don't pay the premium. The policyholder pays the premium. The monthly deduction is taken out by the insurance company. The statute itself distinguishes, I think, in 4 different sections between charges that are deducted from the premium, I think that's in maybe A11, A16, and A1 itself. It distinguishes between charges or deductions and premiums. The refund requirement calls for a refund of premiums that are actually paid by the insurer. The waiver of, the fact that it excludes waived premiums just underscores they're talking about premiums that are actually paid, not premiums that were waived.
Counsel, getting back to the statute, our
Yeah.
our charge is to effectuate the intent of the legislature in how we interpret the statute. And again, putting it in overly simplistic terms, my reading of that section of the statute is that the legislature intended that payments for coverage that were made but not used because of death should be returned to the customer. So why is it so irrational or risible for the other side to view their monthly deduction, which they acknowledge is a payment for coverage, as the portion of the payment that should be refunded.
Well, first of all, monthly deduction's not a premium. The statute distinguishes between premiums and monthly deductions, and it calls for refund of premiums, not monthly deductions.
Right, but that all goes to how you define premium.
Well, the statute itself, it makes it clear the distinction between a premium and a deduction taken out by an insurance company. And it doesn't call for a refund of the deduction, it calls for a refund of the premium actually paid. The premium actually paid is something that's paid by the insured. Think of it this way. If you asked, when were the premiums actually paid on this policy, you'd look at the list of the premiums, you'd say, oh, they're paid once per year exactly on the policy anniversary, 8 years in a row. That's when the premium is actually paid. Their view is it was paid, no, it was actually paid every month.
But I
the
guess this goes back to maybe the very first question from Judge Troutman. This is a vehicle that does many things. It's part life coverage, it's an investment vehicle, it's a tax shelter in certain ways, and they're paying in once annually for the benefit of these many multifarious features of this very specialized instrument. And to me, the statute just deals with the coverage portion of it. I don't see that it requires a refund of an investment, which to me is, at the end of the day, what your argument seems to be.
And that's why, back to my original answer to Your Honor's question, was that I agree that's the key issue on this appeal, is whether you want to read of coverage into the statute. It doesn't say it. The legislature knew how to say of coverage. In 2008, it's important to realize and to take into account that in 2008, the legislature specifically amended the same statute, A1, which is the interlocking provision, to add stuff about UL policies. A2, which is the provision we're talking about, explicitly covers universal life policies. Nobody doubts that. The grace provision part of A2 applies to universal life premiums, universal life policies, and in fact, it refers back to the rules set forth in A1 that was amended in 2008. So the legislature in 2008 was adding stuff about UL policies and the interlocking provision. If at that time it thought that it wanted to exempt UL policies or thought that they should be exempted, it would have done so. The presumption is the legislature is aware of the rest of the statute, and that what it doesn't change, it accepts. There are two explicit exemptions under the statute for two types of policies, paid-up policies and single premium payment policies. There's not an exemption for UL policies. Under black-letter law of this court, that means that there's no exemption for UL policies.
Yes, of course.
So I take it you're arguing that under Lincoln's interpretation, that 3203A2 has no application to universal life policies. Is that my understanding you correctly?
Yes, I think that
So
I'm sorry.
in a circumstance where the deductions, I take it they could be quarterly, for example. You can only have a monthly deduction?
In practice, yes, and A1 actually assumes that. If you read A1, it talks about the charges necessary per month.
There's something in the statute which precludes assessment of deductions on a quarterly or semi-annual basis?
Well, A1 again assumes the charges are assessed monthly. And the ACLI, which is the Insurance Company Institute, says that the mechanics of universal life policies are well known. They're monthly deductions. So
If it was assessed on a different basis, I assume that this provision would apply just as it would to a term policy, no?
well, no, because it's still the same problem with their interpretation of the statute, which is that they're suggesting that it's the monthly deduction that's refundable. It doesn't matter whether the
I
monthly
understand,
deduction is
but-
3
but
months or
if
6
the deduction was taken on a quarterly or semi-annual basis as opposed to a monthly basis, I understand you're also saying that's impractical as a matter of industry practice, and you're suggesting the statute assumes otherwise. But if it was, wouldn't the refund, if the individual died in month 1 of the quarter or the 6-month period, wouldn't they still be getting a refund in the same terms that you would under a term policy?
No, because again, that would be assuming, that argument only works if you assume that what's being refunded is the deduction that the insurance company takes out. That's not what the statute says.
So
The statute,
you would not have a claim for a refund in that circumstance, is
well,
your view?
I'm not saying there wouldn't be a claim for, I mean, if the court were to interpret the statute to mean that, of course, there would be a claim for it. But that's not what the statute says. The statute refers to a refund of premiums that were paid. It doesn't matter how long the deduction period is. The statute refers to deductions at least 4 times, I think. It doesn't say you get a refund of the deduction, it says you get a refund of the premium. The last point I'd just like to make is, of course, and I think it's just essential here, is that even if the court were to read an of coverage rule into this statute, this premium, this plan premium satisfies it, because this plan premium there's a rider, a secondary guarantee in this policy, which means that if you pay this plan premium every year, as this insured did, you are guaranteed to keep the policy in force for a year. There is no possible interpretation of the statute that says that an annual premium that guarantees to keep the policy in force for a year somehow is not payment for a period.
Thank you, counsel.
Yeah, thank you.
Good afternoon, Your Honors. John LaSalle from Boyes, Schiller, Flexner for defendant, respondent, Lincoln Life and Annuity Company of New York. I'd like to go back to one of the questions that Chief Judge Wilson asked, which is, if the language about the premium frequency isn't in the policy, would the plaintiff have a claim for a refund? And the fundamental point here is that that language is in the policy. The policy explains that the premium frequency, which is chosen by the owner, and as listed on page 1, it says the premium frequency is how often you intend to pay the planned premium. It refers to the recurrence of an optional payment, which is the planned premium, which is a mechanism by which the owner funds the investment account. As Judge Troutman pointed out, this is a hybrid policy where there is an investment component and there is an insurance component. Premiums are paid to fund the investment component. And from that component, which is called the policy account or the policy value, the insurer takes...
Is there an IRS reason, reg reason why you have to call it a premium? I mean, why don't you just call this an investment?
The policy is structured so that it qualifies as life insurance, which has to
Right.
do with the limitation on how much funding can go in. I can't remember which of you asked the question, can you have such a high policy value that you don't have any
Let
monthly
me ask it a
deduction?
different way. If you called it a contribution, would you still get the same tax treatment?
It would function the same way. I'm not certain whether or not under the IRS guidelines it would continue to be treated as life insurance, but the overall objective of any limitations on the payment of premiums is that this policy will continue to be treated as life insurance, which is...
Can you help me understand the economics of this? So I take it with option 1, your view is that the statute allows you to retain everything that remains in the policy account, and you have to pay out whatever the face value of the policy is. I think it was $1.5 million. Is that right?
That's correct.
Okay. So why does an insured pick option 1? What are the economic benefits to doing that?
Sure. So on option 1, the monthly charge is lower.
The monthly deduction,
The
you
monthly,
mean?
the cost of insurance charge, which is part of the monthly deduction, is lower because it is offset by the amount of the policy value that remains in the investment account.
So if I have $10 in my account and my, policy value is, my life insurance value is $8, that's what I get upon death, it's because you'll be able to take that $8 or $12 or whatever it is out of that, and you'll only be out of pocket whatever the delta is that
Essentially,
right?
so the insurance company charges for the amount on which it will be on the hook. So you have $1 million policy with a $200,000 policy value, the insurance company is on the hook for $800,000. So they're only going to charge you insurance on the $800,000, which is another benefit that having a higher policy value creates. The higher the policy value, the lower the charge for the
And
insurance.
is that essentially the whole basis for the variable monthly deduction? The actual policy values fluctuate over time? Or is there more to it than that?
The policy value fluctuates over time. It gets larger when you fund the policy value through a premium. It gets smaller when the monthly deduction, which is what extends the coverage, is taken out each month.
What about if you take a loan or something like that? Would that reduce the policy value?
It reduces the policy value, and upon death, if you have not paid back the loan balance is taken from the face amount of the death benefit.
And so let's say you funded $1 million of this account, you have a 1.5 million benefit, you choose option 1. It goes as an insurance payment to the beneficiary, untaxed, right?
Correct.
Instead of $1 million transfer in an estate.
Correct. And the money in the account value, the policy value, is credited interest every month. That interest grows at a tax-free rate.
Can I again ask you about, well, not ask you, again ask, first time for you, how you read the statute on a typical whole life policy?
Sure. So on a typical whole life policy, the owner is faced with an all or nothing choice. Either you pay this premium, and let's call it a 12-month premium. You pay that premium, you get coverage. You don't pay that premium, you don't get coverage. The legislature steps in to say, that's an instance where you may be overpaying for the coverage. You paid for a year, you didn't get coverage for a year. In this instance, the fact that premiums can be paid in any amount after the initial premium gives the owner the flexibility to pay the absolute bare minimum or a level amount that will continue the coverage for some period of time, or a higher amount for the first 10 years and then a lower amount afterwards. So in that instance, in a whole life policy where you have paid the premium, you've paid facing that all or nothing consequence, and you've paid it for, let's say, the 12 months, if you die in June, there are 6 months for which you have paid for coverage and you don't get that coverage.
And so that's parallel with term life.
It's parallel with term life.
So the way you would read the statute is the refund provision applies to term and whole, but not variable.
Because of the language of the statute. Because the language of the statute does not capture this type of policy that has a investment component and a monthly deduction,
Well, there is
which
an
extends.
investment component in whole life, sort of, right?
It has.
Your premium payments are earning some money that is going to fund the death benefit.
In some ways, there are parallels, but the flexibility provided by a UL policy distinguishes it from paying.
And that's what I'm getting at. It's not so much the investment component of it, it's the flexibility or lack of flexibility in the contract itself.
I think those two things are related because the policy, the investment account is what earns the interest, what allows people to invest in a UL policy, take that money out to pay for tuition at one point in their life.
Which you can do with a whole life policy, too.
That is correct, but the investment component is what I think differentiates and makes clear, because of the difference between a whole life policy and a UL policy is that in a whole life policy, the deduction is what extends the insurance coverage on a month-to-month basis. Whereas in a whole life policy, you still have to pay the X many dollars in January if you want the coverage for the next.
Is it your argument that 3203 doesn't apply to universal life policies at all?
I think that there are readings of the policy that can apply. For example, under the DFS's guidance in the product outlines, it talks about refunding the amount applied to the policy. That's the monthly deduction. So as Judge Halligan had asked about, if there's a policy that takes deductions on a quarterly or semi-annual or annual basis, and that deduction is taken out, or if you have a monthly policy that is taken out in error, where the deduction thereafter is taken out in error. For example, they don't make a claim until February when the insured passes away in January. Under the DFS's reading of the statute, you would tack on and refund that portion of the monthly deduction.
What about the provisions relating to the underfunded account? Like if the account goes into the grace period for payments, I mean, it provides remedies for what happens if the person dies during that, while the account is in its grace period.
It explains that if you die in the grace period, and if you die in the grace period, the company can deduct from the death benefit the amount needed to continue the policy.
Correct.
Now, this is, I think, a very important point because it leads to absurd results under the plaintiff appellant's interpretation. If those options, so the planned premium is an optional payment, optional choice. under their interpretation, it would fall under the definition of any unpaid premium in the grace provision. They have an argument where they say, no, 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 that's referring to the 3-month sufficient payment. The statute says any unpaid premium. If a planned premium is, for purpose of the statute,
You'd be able to deduct the whole
you'd be able
planned
to
premium.
you'd be able to deduct the portion of it. And even if you deduct $1 of it, it is inconsistent with it being an optional payment. This is the type of absurd reaction, absurd consequence that the lower court recognized in applying the district court and the federal district court in applying the plaintiff's
So
interpretation.
based on that answer, it would seem to me that you would behoove you to take the position that the statute applies to universal life policies. It just applies in a unique way because of the structure of these accounts.
I do not believe that the statute applies to this particular premium payment that was made. So
Well, inasmuch as the argument is that
it does not
it's-
pay.
the whole thing is a premium.
It doesn't pay for a period. In the plaintiff appellant's reply brief, it made the claim that the statute is somehow agnostic as to what the period is for, and said it could be for coverage or costs or Lincoln's bottom line. That defies grammatical sense. You can't have a period of a company's bottom line. The period of coverage is what's being paid for, and this is an unearned
Well, but
premium
that's where I
statute.
get hung up a little on whole life, because the premium payments for whole life are paying sometimes for a future period of coverage, right? You're building up value in the policy.
They can in certain, I think
I
there's
mean, if you have a flat payment over, in your whole life policy, your
builds
premiums
up the-
today, when you're young, you're essentially building up value to pay for a later period when you're older. So I get a little tied up when you say the distinction here is because it's not paying for the period of the coverage.
between whole life and universal life.
Yeah.
Let me see if I can do that a little bit clearer. There is an element in a whole life policy of a dividend or a value that gets built up over time that can be used to offset future
Correct.
future payments.
And the future payments pay for the insurance coverage when you're older and more likely to die.
That is correct, but you're not tying the payment of a premium to any period under the UL policy or the whole life policy that you just described.
Well, it seems to me a cleaner argument for you that there's flexibility in the UL policy, that there's no structure of a contract, doesn't require a payment, and therefore the payment is not for a period because it's essentially the policyholder's gratuitous discretion about what to do, than to try and figure out what the payment is, what the money of the payment is being used for, and whether it's being used for the coverage of this period or some future period, because I think that gets you into a tangle with whole life.
I think that I agree. I can justify it under both ways. The first way that you described, the premium payment does not pay for a period. It can be made, the planned premium can be made, it can be skipped, it can be used to fund the account value. Well, it's always used to fund the account value. I think the way we're seeing each other a little bit differently is that under a UL policy, the premium, the coverage is extended on the month-to-month basis through the monthly deduction. It doesn't matter what the, quote, purpose of the payment is, it's the mechanics of the policy say that we are going to extend the policy. You don't run into the grace period until your account value is too low to cover the next month's monthly deduction. My adversary made an argument towards the end of his presentation about the planned premium, the guaranteed rider. The rider is simply a mechanism by which the grace period does not go into effect. It is paid for through the monthly deduction, which is what also funds and extends the period, the premium coverage. And it does not pay for a period of coverage, just like the planned premium, the optional planned premium does not pay for a period of coverage.
if we disagree with your argument, we accept his argument, how are policies in the future going to change?
I think that's a very good question, Your Honor, because the industry, as you can see from the ACLI, has put in a amicus submission. I don't believe the court has granted or denied that motion, but the essence of that motion made by the ACLI, which is the trade group of life insurance companies, is that that money has to come from somewhere. When you develop a term policy, you develop how much the premiums are going to cost, and part of that is going to be developed with the idea that there's a refund built in by the statute. This statute's been on the books for 100 years. There's no case law interpreting the statute. The money's going to come from somewhere. It can come from, for existing UL policies, it can come from non-guaranteed elements, which can be adjusted. For new policies, it'll be built into the cost of setting those structures.
Wouldn't it just make all the policies option 2 policies?
It would give a windfall to anyone who chose option 1, because they could have chosen option 1, and option 2 is more expensive. Option 2, you have to pay for the entire
Right.
face amount each month, the deductions
So will
on the entire
option
face
1
amount.
policies still be possible under that reading?
I think it does do significant damage to the election between option 1 benefits and option 2 benefits. I also believe that we will be before the courts seeking guidance as to what happens if someone doesn't pay a planned premium or pays 2 planned premiums in 1 year. Which portions of that do you deduct? If the funds were already sufficient to carry the policy through those first 12 months, what will you refund all of the planned premium? Will you refund both of the planned premiums? Is it first in, is it first out? Courts will look to this court for making up those rules, because those rules cannot be divined or understood in terms of the statute. Another helpful way to look at this, Your Honors, is there's a series of intervening events that can happen between the payment of a planned premium and a period of coverage. You can shorten any length of time that the policy would be in effect by changing the death benefit, by switching from option 1 to option 2, by taking a loan against the policy, by taking a partial surrender or a complete surrender. All of those are contingencies that are going to drive a wedge between the simple payment of a planned premium with 12 months in between those payments to an actual extension of coverage. My adversary said it was dispositive whether or not the words "of coverage" appear in the statute. They don't appear in the statute. We believe that that is the only reasonable way to read the statute, which has multiple references to a period that is being paid for. The thing that is being paid for is the insurance coverage. But even if you were to agree with my adversary that "of coverage" is not in the statute, and that's not what the statute is talking about, you still have the fact that the only thing that is extending coverage is the monthly deduction. And the monthly deduction is what is coming from the policy value, the investment component of the policy.
Thank you, counsel.
Thank you.
Thank you, Your Honors. I'll start where counsel left off. The statute doesn't say "of coverage." That's dispositive. The court is not allowed to add words in the statute. They're not there. Again, think of your whole life example. If the whole life premium says you pay $1,000 per year, and part of that premium is for an annual administration fee, if you look at the statute, you clearly get the balance of that paid back. That's not for coverage. If part of that premium is for access to a help desk and it's optional, you still get that back. The evil that the statute is trying to prevent is the one that's written into the statute. It's payment for a period beyond when the insured dies. It doesn't matter whether the payment is for coverage, for administration fees, for a help desk, or anything else.
So the
It's not in the
evil,
statute.
what you describe as the evil that the statute is trying to address does seem to me a little bit different in a circumstance involving term or whole, where the policyholder must make the payment under the terms of the contract, and a variable policy, where the policyholder can make it but doesn't have to make it. To put it a little bit differently, your client could have avoided what you're calling the evil by making monthly payments of the full amount instead of the annual, no?
Well, no, in fact, the only way to pay this policy cheaply is to pay the annual premium every year, once per year, exactly like a term policy.
Sorry, why couldn't you divide that by 12 and make a monthly payment?
Because there's two separate accounts. There's two separate ways of testing whether the policy stays in force. The one is you look at your cash value and you look whether it covers the regular monthly charges. That's one. It's an accounting mechanism. The second way is the CPGR, the secondary rider. Under the secondary rider, if you have enough to cover the secondary charges, which are fixed and guaranteed and don't vary, then the policy automatically stays in force. Counsel said payment of CPGR premium doesn't provide for coverage. I don't understand what that means. This policy stayed in force in one and only way, by paying that CPGR month or annual premium exactly once per year. The policy itself on JA 64 says if all premiums are not paid by the premium due date, additional premiums will be required. That's for the CPGR. That's just like any other policy. That's just like a term policy, just like a whole life policy. If you don't pay your whole life premium, by the way, you don't automatically lose coverage. You get a grace period. What happens is you may have to pay some fines. If you don't pay your mortgage payment on time, it doesn't mean you lose your mortgage necessarily. You may have to pay extra fees. The exact same is true here. The court cannot answer this question no categorically. The answer has to be at least it depends on the policy. Everybody agrees this statute, A2, applies to universal life policies. That's not in dispute. The legislature amended in 2008 to make it clear as day this applies to UL policies. The rule cannot be a categorical no. It cannot be that it doesn't apply to any UL policies. The rule might be, yes, a plan premium counts, provided it's sufficient to cover the premiums for a year, like this one is. It could be yes, provided it's
If you go
sufficient.
with your rule, then would they have to recalculate how much the insurance portion costs based on the risk the insured dies, and they have to refund the $50,000 that they've counted essentially as self-insurance for that premium?
I'm not sure I totally follow the question, Your Honor,
So
but
when
yeah, I think the answer is
you
yes.
pay $50,000 in, let's say, just to make it a round number,
Yeah.
what's left is the $50,000 in the account after they take the load charge off. And as I understand it, they calculate the value of, the cost of your insurance part, let's just call it, the $1.5 million that you're going to get paid, based on almost a self-insured analysis of how much is in your account, right? So if you have $400,000 in the account, essentially, they're calculating risk based on 1.1 million, right? That they have to insure over that, assuming option one.
That's right.
But now, should they also factor in, well, if you die next month, they got to give you back most of that $50,000. So should that really count in terms of how much you have to pay for your term life? Or is that another risk they should factor?
They say that under the terms of the policy, that would count. We actually quantified that in our brief, and I think it's something like a $130 difference. Because when you're talking about...
But doesn't the fact that they don't do that and go to what the agreement was here? They're
No,
not,
no, no.
They would be factoring in that risk if they thought they had to give that money back to you, right?
No. They're not factoring it in because they're not interpreting the statute properly. That's the whole problem here. If they were interpreting the statute properly, then they may calculate the net amount at risk slightly differently, but it would make a minuscule difference. It'd be about a $100 difference.
Let's say you got a $100,000 policy and you put $50,000 in, that's a big difference, right? Like,
Well, yeah, but you couldn't even have a $50,000 plan premium for a $100,000 policy because it would get way too high. But yes, I mean, they're just the mechanics of how net amount at risk are calculated. Those are complicated. The insurance companies have actuarial software that allows them to do it.
but it seems like this has all been going along, and maybe it's X amount this year, but this is going on year after year where you get the benefit of putting $50,000 in, taking that off of the amount that you have to pay for coverage of your benefit, and then all of a sudden at the end you say, no, I get that money back.
The fact that they have been misapplying how they calculate net amount at risk, they say, isn't a reason to not interpret the statute in the way it's supposed to interpret it. Of course, there's one other example in the record of a situation when an insurance company was faced with the question of whether the refund was owed. Athena Life, New York insurance company, the same insured had a UL policy with Athena Life. Athena Life paid the refund. That's the only evidence that there is of what, other insurance companies do in this situation. They paid the refund.
So you're saying they were factoring in that risk, that they'd have to give back the account value portion of it as well?
I have no idea, but the fact that I don't know how they did their internal accounting. I don't know how Lincoln did its internal accounting. Maybe Lincoln does factor it in. I don't know. There's no way of knowing that on this record. It's a motion to dismiss. But if it did have to factor it in, the statute required it, then okay, so it's something their actual software can do.
What was the policy value of this account at the time of the death?
Great question. There's actually a motion that we filed to supplement the record because this was all decided on a motion to dismiss. Lincoln sent our client a policy statement the year, right before they paid the last annual premium, right before the insured died. It shows that if you paid the annual premium $58,000 or $53,000, that the policy actually would lapse within that year if it wasn't for the guarantee. The guarantee is what was keeping this policy in force.
So is it fair to say that your client was using this GVUL policy effectively like terms?
Yes.
Okay.
Exactly. And that what they sent us shows that. It says explicitly that if you pay this annual premium exactly once per year, you're guaranteed to have the policy stay in force forever.
So help me with one more thing. Why would it make, my impression is if you had taken out a term policy instead of a GVUL policy that you were intending to use purely as term and not build cash value in it, it would have been cheaper to just get the term policy.
I don't know that's true, Your Honor.
Okay.
I don't know that's true.
Okay.
But this policy certainly is cheaper to pay as a term policy.
But do you know the answer to the question how much money was in the account at the time of the...
The court has access to that information because we tried to submit something that supplement the record. That's an account statement from them. I don't remember what the answer is, but it's in there.
Record.
But it's not in the record because our motion was denied. But if the court is curious, they can look at the account statement that Lincoln sent our client the year before it dies, which shows it's in the policy, and it shows that the CPGR means that if you pay this annual premium once per year, every year, you're guaranteed to keep the policy in force for the following year. And if you don't pay it, your penalties are assessed, and you lose the CPGR coverage. The only rational way to keep this policy in force is to pay it once per year, every year. And it makes it indistinguishable from the term policy.
Thank you.
Thank you, Your Honors.